Good afternoon. Welcome to the first ASBO Hot Topic webinar of the year. Today's topic is School Year 2011-2012 Legal Review. Today we have Kathy Ahern from Gersio & Gersio here to speak with you. Now, if you have any questions throughout this webinar, you do have the ability to ask them. But the first thing you have to do is type in your audio pin into your phone. You can find that in the audio pane on the right-hand side of your screen. If you have not typed in your pin, you can't ask any questions. Now, to ask questions, you do have a button labeled Raise Your Hand. Click that button. That'll notify me as the moderator that you have a question. I'll then break in, and you and Kathy will be able to speak. Again, if you have not entered that pin, you cannot ask any questions. So with that out of the way, Kathy, it's all yours.
Thanks, Matt. Good morning, everyone. Welcome, as Matt said, to our year in review presented by New York State Association of School Business Officials. My name is Kathy Ahern. I'm a partner in the firm of Gersio & Gersio. And this morning, what I'm going to do is try to divide the presentation into two parts. The first part is going to be about significant decisions that we've received from the courts and arbitrators and PERB, and also the Commissioner of Education. And the second part, we're going to talk about changes in state law, some of which were happening right up until yesterday, as you will see. And sort of interspersed in there will be amendments to Commissioner's regulations. Obviously, we can't cover every case that's been handed down, but what I've tried to do is pick out some that are most interesting and have the greatest impact for school districts over the next year. So let's start on slide 3. This first case answered the question of whether or not the New York State Division of Human Rights has jurisdictions over race and disability discrimination complaints that are brought by students against their public school districts. We know they have jurisdiction over complaints brought by their employees, but what about students? Well, our highest court in the state, the New York Court of Appeals, answered that question in the negative in the case that you see there that was decided just last June 12th. What happened in this case is that we had a couple of public school students. They sued their school district for race and disability discrimination under the executive law. And most of us know that law as the human rights law. And I've written the language right there so you can see the provision under which they proceeded, because that provision in the language is important. It says that it's an unlawful discriminatory practice for an education corporation or association which holds itself out to the public to be non-sectarian and exempt from taxation to permit harassment of any student by reason of his race or his disability. The school district said, wait a minute, we need the court to issue an injunction preventing Division of Human Rights from investigating this because DHR doesn't have jurisdiction over us. We're not an education corporation, as that term is used in the provision that I just read to you. Now, the trial court agreed with the district, and they stopped DHR from investigating. But then it went up on appeal. The students brought an appeal, and the appellate court agreed with the students and ruled that the investigation can go forward. So it was left to the Court of Appeals to sort of be the tiebreaker. The Court of Appeals looked at the statute and said, well, how do we know what an education corporation is? The language is used there, but it's not defined there. So it jumped to something called the general construction law, which we lawyers basically go to when there are no answers or definitions in other parts of the law, and looked at this earlier case that came out of East Meadow, which had held that because a school district is a municipal corporation, as we all know, and therefore a public corporation, it can also be an education corporation. It also analyzed provisions of the tax law, which I won't go into, pretty boring stuff. But based upon that language in the general construction law, the court concluded this is not an education corporation, and therefore the students have no cause of action under the human rights law, and DHR has no authority to investigate or decide student complaints. Now, that's really important to us for this reason. The Division of Human Rights is in the business of determining whether there's probable cause when these kinds of complaints are brought. And they can institute remedial orders, and even allow plaintiffs to go forward in court proceedings. And many of us attorneys who practice before DHR have found that DHR often issues probable cause findings, even though the evidence might not support probable cause. The cynic in me says that's because this agency and its survival really depends upon making sure it finds probable cause, and so oftentimes districts get the short end of the stick. So if we can avoid having those student complaints before DHR, districts are better off. Of course, students still have other avenues for complaints, federal law and the new DASA, Dignity for All Students Act legislation, which we'll discuss later, but at least not before DHR. The next case is on school funding. It answers the question of whether the CFE case, Campaign for Fiscal Equity litigation, is the final word from the courts on a sound basic education. Apparently it is not the final word, because in this case, Hussein versus State of New York, the Court of Appeals refused to dismiss a complaint brought by 11 plaintiffs, mostly small city urban school districts, claiming that their students are deprived of a sound basic education because of inadequate funding by the state. The state had argued that it should be dismissed because it's moot. The state said we've been down this road before with CFE, and the court rejected that. The state also argued, sort of contradictorily, that the case isn't ripe for determination by a court because it's based on old data that was gathered when the complaint was first filed many years ago before it went through this motion practice. Both the Supreme Court and the Appellate Division disagreed. They allowed the complaint to proceed. The Court of Appeals, our highest court, also allowed it to go forward. And the court found that it's likely that plaintiffs may be able to prove that the reforms that were enacted as a result of CFE were not even enough to provide a sound basic education. Well, what's the practical upshot of this? I said there, don't hold your breath, because the CFE plaintiffs are still waiting for the remedy that the state imposed and the money that the state was said was coming to come to New York City, which was primarily the plaintiff there. And no one really knows where this money will come from. So this case is likely to drag on for some period of time before there's any real resolution. Open meetings law. We had changes this past year, which we will get to. But this particular case is really interesting. It's gone all the way up to the Appellate Division 4th Department, not to the Court of Appeals yet, but to the middle level appeals court. The question here is it enough for a motion for executive session to just recite the statutory categories for moving into executive session? And the Appellate Division said, no, it's not. As you all know, if you're going into open meeting, if you're going into an executive session, the school board has to have a motion, a second, and the majority must decide to go in executive session. But the rationale has to be articulated in public session. And the rationale is set forth in the statute. And there are a couple that are very common, which you see there in the first bullet: proposed pending or current litigation, if you're going to discuss collective negotiations under Article 14 of the Civil Service Law. And usually boards just sort of parrot that language. Well, the lower court here out of Onondaga County said that's not enough. And it found that the school board there violated the open meetings law 3 times because it, quote, merely recited statutory categories for going into executive session without setting forth more precise reasons for doing so. Well, the case went up on appeal by the school board, and the Appellate Division agreed. The school board lost and said you have to use more specific rationale, and that has to be articulated publicly. And I put the exact quote here, which is full of legalese that the court said, but basically what it comes down to is the courts want to see sufficient detail in that motion so that a person sitting in the audience or reading the minutes later on can be able to determine whether or not the purpose of going into executive session was legitimate or whether it was just to have a secret discussion. The problem here is neither the lower court nor the middle court gave us any real instruction about how specific that language must be. Is it enough to just say we're going in to discuss current litigation, or do we have to identify the litigation? That potentially creates problems because if you're talking about a particular litigation, you may be talking about a settlement strategy, and you may not want someone in the audience or the plaintiff to know about that. Is it sufficient to just say matters leading to the discipline of a particular person? Here's a place where school boards really get in trouble. You probably heard your boards often say things like, we're going to have personnel discussions. That's clearly not enough. You have to say matters leading to the discipline of a particular person, but we know you can't identify the person, or you could be violating the personal privacy law. So my suggestion is to do something like matters leading to the discipline of a particular person under Section 75 of the Civil Service Law, or something like that. So be careful, or you can trip up on those requirements. And if you do, here are the consequences. A court can void any action the board took, and now there is a provision for the person who challenges the action and prevails to get attorney's fees, and the school board members can also be sent for mandatory training. Disclosure of teacher ratings. This case is relevant to something I'm going to talk about later on in a change that was just made in the law in APPR. Sorry to say that four-letter word. I'm not going to talk much about APPR today. But this was a case that came out of New York City. In this case, New York City, before APPR, had created these things called teacher data reports. The teacher data reports basically attempted to compare a student's predicted improvement on state tests with the student's actual improvement or not, and then attribute those gains or losses to a particular teacher who was identified. So New York City had these TDR reports, and as you might predict, they got a FOIL request. They turned over the TDR reports, but they deleted the teacher's name to protect personal privacy. As you also might predict, they got another FOIL request from the press after that. It said, we want the teachers' names. The union went to court to preclude or enjoin the city from releasing the teachers' names. And a state appeals court found that the release of the teachers' names is appropriate under FOIL, that it would not violate the personal privacy laws, because the personal privacy laws are in place to protect release of information which would be offensive to a reasonable person. And the rationale was releasing the teacher's name would not be offensive to a reasonable person, particularly if that teacher rated fairly well. The court rejected the union's argument that the data should not be released because it was flawed. You know, this is the argument that's been going on under APPR about whether or not the data is accurate, whether it's reliable, and whether it was ever really intended to measure teacher performance in the first place. But the court said there's no exception under FOIL for incorrect data. You can still release it. Now what happened here is this case really paved the way for the legislature to amend the APPR law to ensure that only parents receive individual teacher composite scores, and that the public receives those scores or information on an aggregate or non-individualized basis. And when we get to the part about new laws, I'm going to talk about that in some detail. But this case is really the catalyst for that change in statute. Discipline of tenured employees. Very important case here. This is sort of amazing how this hearing officer decided this. Can a Board of Education bring disciplinary charges against a tenured employee based on the same conduct that had formed the basis for a prior counseling memo, or what we all know are called Holt memos? Well, the Supreme Court in Yates County said, yes, that's fine. You can bring a 3028 proceeding based upon behavior or actions that gave rise to an earlier counseling letter that you sent. And the reason this came up was because a teacher was charged, but the hearing officer in this case refused to impose penalties on the matters that the teacher had previously been counseled on in the Holt letter. In the absence of proof that that teacher had repeated the violations after he had received the counseling memo. Well, the district didn't prove that he had repeated the violations after he received the counseling memo. They were the same actions. So the hearing officer held, and you see the language here, it would be inherently unfair and totally contrary to just cause to issue further discipline to the teacher for actions that were never repeated, and I won't do so. And there's a reason that I highlighted further discipline here. because you'll see that the district appealed this to the court. The court agreed with the district. The court said the hearing officer fundamentally misunderstood the purpose of a counseling memo or a halt memo. The counseling memo or a halt memo is not a disciplinary action. So when you go back to the prior slide here, he called it further discipline. It's not further discipline. The counseling memo is merely to advise, to counsel, to recommend. That's why your lawyers, hopefully, when they help you or review what you've written to teachers, make sure they have that language in there, that this is not a disciplinary action and that this doesn't preclude further action, i.e. discipline, based upon the same issues that have been raised in the letter. Sale of school district property. Here's a commissioner's case where the commissioner tells us what the fiduciary duty is of school officers and school boards if it's going to sell school district property. Appeal of White, we had a situation where the board voted to close an elementary school, designated surplus, and sell it. The board went out and got an appraisal, and you see the other appraisal was $5.6 million, and it decided to use an RFP process. The board had some flexibility here, by the way, can use any sort of fair process in a situation like this. So they chose an RFP. They got 3 bids, $1.65 million, $4.6 million, $3.1 million from a local congregation. But for some reason, the board then authorized the attorney for the district to obtain a second appraisal, which came in at $3.24 million. The board accepted that appraisal, lower than the initial appraisal by some $2 million, and then accepted the congregation's $3.1 million bid. Well, what happened to the $4.6 million bid there? As you might predict, a concerned taxpayer, there's always a few of those in the school district, appealed to the commissioner. Commissioner said, when you sell real property, the board has a fiduciary duty to get the best price obtainable in the board's judgment for any lawful use. And as I said, the board had the authority to figure out how they would ascertain the best price possible. Notwithstanding that authority, a board can act arbitrarily, and it's got to exercise its judgment in good faith. And here, the commissioner said the board should have attempted to reconcile the discrepant appraisals. That was its first mistake. And then to really think through whether the method it had chosen to get bids was really calculated and targeted to get the best price. Plus, the board moved very quickly here. If you read the case, you'll see not much time elapsed, and that sort of put fuel on the fire about whether it acted arbitrarily or exercised its best judgment. So this is an area board has to be careful and something that school business officials can be helpful with to them. School district liability. Our friends in the Schenectady City School District are still struggling in the aftermath of an employee there who you've probably read about in the paper. This case arose out of that particular, not just incident, but course of conduct. It held that a school district can be liable. The district itself can be liable for negligent retention and supervision of an employee who's hurting other employees. In this case, the 2 plaintiffs were both employees of the school district, and they claimed that another employee used his position and power to conduct a reign of terror against them. There was vandalism, there were threats, there were mini bombs left in their mailboxes, etc. The district moved to dismiss the complaint, and they only succeeded in dismissing half. The claim for intentional infliction of emotional distress was dismissed because the court found that a school board can't be held liable for that when the individual was doing what he was doing for personal reasons and it was not in furtherance of the district's business purpose. But the district can be liable for negligently supervising and retaining an employee under this standard that you see in front of you. If the board knew or should have known of the employee's propensity to engage in the conduct that caused the injuries, and if those injuries were approximately caused or directly caused by the failure of the board to supervise, and the employee was not acting within the scope of his employment. Now, we don't know if the school district will, in fact, be liable. All this is that the school moved to dismiss early in the proceeding. The court denied it because the court said a case for negligent supervision and retention has been articulated. Now they'll go through discovery, and maybe they will get to trial, and we'll be talking about this case next year and seeing where it came out. But this just shows that districts and administrators have to be diligent in supervising their employees. The allegations here were that many complaints were made about this employee and his behavior and that nothing was done. Again, just allegations. Interesting case here on bullying. This case, coming out of a New York federal court, arose because a parent claimed that their disabled child, who had an IEP under the IDEA, was being bullied and harassed because of his disability, complained numerous times to the district, and even raised the issue at the CSE meeting. The court said that the standard to be applied is whether school personnel were deliberately indifferent to those complaints or failed to take reasonable steps to prevent the bullying, and the failure substantially restricted the child's educational opportunities. If those facts are proven in discovery and trial, then what you will see is that the court will sustain or support the idea that a child can be denied a free, appropriate public education, a FAPE, by virtue of the fact that the district has not taken appropriate action to protect the child from bullying and harassment based upon their disability. So that's an interesting new twist under the IDEA. Partisan election activity. Here, a school district put up 16 signs that it purchased around the district, and a bunch of them were right on the edge of district property. And they said, vote May 17th, Tuesday, Penfield Senior High School, 6 a.m. to 9 p.m. Another concerned resident challenged this to the commissioner, claiming that it violated Phillips v. Maurer. You know that's the case out of the Court of Appeals that says you can't use district resources or district property to support a partisan position, to support a particular candidate, or even to advocate in favor of the budget vote. The commissioner, though, rejected this claim and said that merely because the signs were posted on or near district property did not transform a sign that was just informational into an inappropriate piece of advocacy. All that sign did was tell people where to go to vote, when to vote, and didn't advocate a position one way or another. So there was no problem. And he refused to hold the school district liable. Employee surveillance. This case concerned, and it came out of a PERB panel, whether or not installing concealed cameras to monitor employees' suspected bad acts is an action that must be bargained, or is it a management prerogative? The PERB panel held, in general terms, the general rule is that the placement of cameras is a mandatory subject of bargaining. You can't unilaterally do it. But that in certain narrow circumstances where videotaping employees is not part of the core function of the employer, like it is in a prison, you could balance the interests of the employer against the district to determine if a specific surveillance for a short period of time could be done unilaterally in the absence of bargaining. So that's a mouthful. Let's see how that breaks down. Here's the general rule. The decision by an employer to engage in videotape surveillance of a workplace for monitoring and investigating is mandatorily negotiable. Why? Well, because it bears a direct and significant relationship to working conditions. It requires employees to be video surveillance participants. In other words, they can't avoid it because they have to walk potentially down a hallway where the camera is behind or enclosed in a place where they can't see it. And it intrudes on employees' interests, including job security, privacy, and personal reputation. The PERB panel noted that the video that is collected or the images that are collected could be used as the basis for counseling, discipline, or demotion, or might even reveal protected concerted union activities or an embarrassing aspect of the employee's life. And certainly all of those factors taken together make it something that's mandatorily negotiable. But whether a particular decision must be bargained, the PERB panel says, requires a fact-specific exam of the interests, a balancing of the employer and employee interests in each case, considering the nature of the workplace, the employer's core mission. The PERB panel here, interestingly, contrasted the facts in this case, which is called Nanuet, versus Elmont. In Elmont, PERB found that it was not an unfair labor practice to unilaterally videotape. But here, if you look at those facts in Elmont, we were talking about complaints that had been made about a school bus driver who was driving erratically. So that one driver was secretly videoed for only 2 days, and PERB found there was no unfair labor practice. But in this Nanuet case, all employees who were using a common hallway outside the custodian's room were being videotaped, and that was a lot of employees. They were taped for 6 months, not 2 days, in an effort to catch one employee who was allegedly abusing break time. Now, the PERB panel dismissed this case on procedural grounds, but the clear implication there is that if it's a broad, general surveillance like it was in this Nanuet case, it's likely that it would be found an unfair labor practice if you try to do it without bargaining it. A much more narrower set of facts would have to support an employer's unannounced videotaping or installation of surveillance. Here's a case where the school board decided to change the eligibility requirements for retirement health insurance benefits and do it unilaterally. The CBA was silent on the issue, didn't speak to the issue. So the school board increased the period of service required for health insurance and retirement from 10 to 20 years. And it also imposed a service requirement for all district employees. And previously, the service requirement had applied only to those employees who were hired after a certain date. All the other employees were sort of grandfathered in. So as you again would expect, the district was met with an improper practice charge. And the ALJ in this case looked at the past practice because the contract was silent. It found an unequivocal, definitive past practice for 7 years of providing health insurance and retirement to those hired after a date certain and to those hired afterwards if they had 10 years of service. Now the district argued, but wait, that was only as long as we could afford it. There was an implied condition here. And the PERB ALJ rejected that and said, if you're going to reserve a right, a policy-based reservation of right in a CBA must be explicit to be enforceable, and it has to be narrowly construed because it's not the product of a bargain between the parties. You can't just say you agreed to this orally. It's got to be something more definitive in order to overcome 7 years of past practice. So the district was found to have engaged in unfair practice because it should have bargained those eligibility changes for health insurance. Here's a case that scared me, and will probably scare you too. This is a case that just happened in May with respect to the Albany County DA. They brought a Section 75 under the Civil Service Law to terminate one of their employees. And Section 75, as you know, requires a written delegation from the Board of Education authorizing an individual like a hearing officer to conduct a disciplinary hearing on behalf of the board. Well, absent a written delegation, either in the form of a resolution, which is what we do with our school boards, certified resolution, or at least minutes of a board meeting, the hearing officer doesn't have jurisdiction to proceed. So in this case, there was no formal delegation. The appellate division, the middle level appeals court, ordered the employee to be reinstated with back pay. The DA is stuck with an employee they did not want. The time frame in which to bring the charges has passed, so the Section 75 charges would be too late, all because somebody forgot to do an official written delegation. Be careful. So now I'm going to move into changes and amendments to statutes and go through that for our second half. We'll start with changes to the open meetings law. These were effective on February 2nd, 2012. And these concern, as you probably know a little bit about them already, since they're supposed to be in effect and we're supposed to be complying, the production of documents or the availability of documents to the public. The new provisions in the law require that when a record or a document is scheduled, it's an important word there, is scheduled to be the subject of discussion by the board during an open meeting, then the board has to make that record available to the public prior to the meeting. It applies to two categories of records. Those that would ordinarily be accessible under the Freedom of Information Law, but also any proposed resolution, rule, regulation, or a policy, or any changes to rules, resolutions, or regulations, or policies that the board is going to discuss. So it's really interesting there because usually drafts are not available under FOIL unless they are tabulations of data, statistics, etc. But here, if you have a draft policy that the board is going to discuss, even though the draft wouldn't be available under FOIL because it's proposed for the board's consideration, it must be made available before the meeting. And if the board has a website, which almost all school districts do now, those records that are going to be discussed have to be posted on the website prior to the meeting to the extent practicable. Remember that language there because that's important. When this statute first came out, everybody got very nervous about how they were going to comply with it because I'm sure your boards, as my boards, we have last-minute changes to the agenda. We have board members who say, well, can we get this on? And then the board president decides to put it on. How do we possibly produce those documents beforehand? Well, again, if you look back at the other language, they are matters that are scheduled to be discussed. Sometimes it's not on the earlier schedule. And they must be produced to the extent practicable. It's not always practicable. So let's look at a few questions here. If a matter is added to the agenda an hour or two beforehand, do we have to post the related records? Well, not if it's impractical to do so. Whether it's feasible, given the totality of the circumstances. Your school board clerk took a break between the day and the meeting at night. You can't get them copied. Make them available afterwards or post them on the web afterwards. The important part is that you act in a reasonable way and that there's no appearance that you're trying to avoid or circumvent the open meetings law changes. Is there a certain amount of time before the meeting when the records have to be available? No. Again, what's practicable? What if the record's posted online but a member of the public wants a copy? A lot of my boards now are just bringing copies to the meeting if they weren't already doing that and having them there. Unless it's a really hot topic at the meeting, you don't often have to make an awful lot of copies. But if it's possible, bring a copy at the meeting. If you're concerned about the expense, you can also ask them to make a FOIL request and you can charge the appropriate fee for the copies. What about drafts or non-final documents? I sort of referenced this a slide or two ago. If it's scheduled to be discussed in open public session, it has to be produced even if it wouldn't have to be produced in FOIL, pursuant to FOIL. So we've got some changes to the 3020A process this year, and this was Chapter 57 of the laws of 2012. It was followed after it was passed in I guess March or something like that, with guidance issued by State Ed on April 4th. The idea here was to reduce costs and increase efficiency. A lot of us, attorneys, business officials, school districts, everybody who knows of the 3020A process, is familiar and has to work with it, have been asking for a long time for changes to 3020A. In fact, some of us, including my founding partner, testified before the Senate this past year. Maybe some of you also did, requesting certain changes. Most of them didn't happen, and some of what they enacted may or may not help. Here's why. Here are some of the changes we have. All evidence that you want to introduce to the 3020A now must be submitted by the parties within 125 days of filing of the charges with the district clerk. This is meant to shorten it up. Hearing officers, arbitrators are already concerned about this. I've filed 3 sets of 3028 charges since under this new law, which applies to all charges filed after April 1st, 2012. One of the ramifications is that my first hearing officer had already written to SED saying, I'm accepting this appointment as a hearing officer, but I want you to know that the councils involved and I have deep and grave concerns about whether we can finish this hearing in 125 days. I didn't really have grave concerns, but I think others on the phone did. But no evidence can be introduced after that deadline except in extraordinary circumstances, and the arbitrator will determine what's extraordinary. SED tells us extraordinary means that rare occasion when evidence truly could not be introduced in a timely manner. So I would guess maybe it's a point in time when a piece of evidence was missing or not available for some very good reason. Otherwise, we'll be precluded from introducing it. Another change, the district and the employee, often counsel for a NICET, must agree on an arbitrator selection within 15 days of receipt of the list of arbitrators from SED. I sort of think that's a good change because sometimes that discussion can go on and on if you can't agree. If you don't agree within 15 days, the commissioner shall appoint an arbitrator for you. Or if you don't advise the commissioner within 15 days and he doesn't hear anything from you, he can do it sua sponte, which basically means on his own motion or his own volition. The commissioner is going to be setting maximum rates of an arbitrator's compensation based upon customary and reasonable fees for services. I'm sure the SED will be discussing that with AAA. I haven't seen them yet. And the commissioner will provide limits on the number of study hours that can be claimed. Basically, this is going to be, I think, 1 study hour for every hour of hearing or something like that, or every day. I'm not exactly sure what they have in mind at this point, but it's meant to prevent the arbitrators from saying they studied for 30 hours that they must be paid for on a case that takes, 6 hours to put on. Also, the state ed will monitor and investigate arbitrators' compliance with statutory time frames. The next piece, arbitrators have to submit their claims for reimbursement within 1 year. I'm not sure why this is here. I don't think arbitrators have been slow to submit their claims for reimbursement. What's been slow is SED's payment of arbitrators, as you all know. It's been a bone of contention for many years. And in fact, there is a lawsuit pending right now against SED brought by 10 or 12 arbitrators who haven't been paid in over a year. Some with fees, some having money owed to them of $100,000 or more. SED is creating new standardized forms that must be used by districts in the 3028 process. Hopefully all of you have attorneys who do this for you. We have a packet of materials we put together with step-by-step instructions for our district clerk and our superintendents. We've had very organized forms. Now SED has some of their own forms, and we've begun to use them as we're mandated to do. The idea behind it is that every teacher have the same information available and that it's uniform across the state. The new law allows SED to use technology, new technology to transcribe the record. We currently use court reporters. I've talked to SED. There are no changes anticipated in the near future about a change in using court reporters, but stay tuned. And supposedly they will update their electronic teach system so that we can have easier access to case information online. I will tell you that the biggest concerns about this 3028 reform among the school district bar and also hearing officers, well, not hearing officers, but the school district bar, is that because of the time frames that are in place, the arbitrators who are viewed as the good arbitrators, fair to both sides, both to the teacher and the district, in whom both sides have confidence, will become scarcer and scarcer and harder to get because they can't take on that many cases. And we see, I was talking to a couple of school district attorneys yesterday, we see that happening already. The lists that we're getting have names of people on there who none of us recognize, so we don't know the quality of those folks. And that's going to be an issue that will play out going forward. The Dignity for All Students Act. Just when you think it's safe to go in the water, it isn't, because DASA, which came out in September 2010, but is on this slide because it was only just effective July 1st, 2012, and also because the Board of Regents has been putting out regulations piecemeal, issuing them in March, April, and June, we thought we were complete in our understanding of DASA. And here you can see all the responsibilities that districts have inherited under the Dignity for All Students Act. But as you will see in a slide or two, there are already amendments to this new law that just went into effect a week or so ago. Under the part that was passed and effective this July 1st, you know that there are additional protections provided to students who are discriminated against or harassed on school grounds, in school buses, or at school-sponsored gatherings or activities when they're discriminated or harassed against based upon their sex, their gender identity, sexual orientation, weight, race, color, religion, religious practice, national origin, ethnicity, and disability. So there's a real broadening there of the categories. Some of these categories were formally protected under federal law and still are protected under federal law, but several of them, like weight, gender identity, are new to all of us. So school districts were in the business of, or in the process of, developing and implementing new policies, amending their codes of conduct to reflect this new law, developing guidelines to be used in training, infusing instruction about this new law into their civility, citizenship, and character education, and importantly, appointing DASA coordinators for each school building, which we had our school districts do at the reorg meetings, because it's important to note that these coordinators must be appointed by the school board annually, not just by administrators. And districts are also engaged in training their coordinators now and designing and implementing a complaint investigation process. So this was really a mouthful to undertake. And mind you, as I mentioned, the federal law, these new responsibilities are in addition to, not instead of, responsibilities that districts have under federal civil rights law, Title VI regarding race, Title IX regarding sex, Section 504, and the ADA. But now, on July 9th, yes, this is an up-to-the-minute webinar, on July 9th, the governor signed amendments to DASA. So the new law has already been amended. The only good news here is that districts don't have to comply with those amendments until July 1st, 2013. So we have some time to get up to speed. And essentially the amendments broaden the definition of harassment to now include cyberbullying, any electronic bullying or harassment, and also to include any action that occurs, and this is the exact language from the statute, off school property, and creates or would foreseeably create a risk of substantial disruption within the school environment where it is foreseeable that the conduct, threats, intimidation, or abuse might reach school property. Let's take a step back for a second. There has been a whole body of case law that has developed before electronic communication and since electronic communication about school districts' ability to discipline students for activity that takes place off school grounds but intrudes upon the orderly school environment. And that often implicates a student's First Amendment rights, particularly when we're talking about postings on Facebook or sending instant messages to schoolmates or classmates that are off school grounds but then somehow bleed into the school environment and incite some kind of disorder on school grounds. And that's always been a very careful balancing test of the school's ability to reach outside the bounds of the school, weighing it against the student's First Amendment rights. And the courts in New York have upheld the school district's authority to discipline students for off-campus conduct when that conduct creates a foreseeable risk of substantial disruption. So what this law does is sort of lift that language out of those cases and that jurisprudence and stick it in a statute and give school districts the authority to discipline students for that off-school conduct under appropriate circumstances. The alarming thing about this is it not only gives school districts the authority, but it gives school districts the responsibility to not only address bullying and harassment that occurs on school grounds, on school buses, and school events, but off of school property. And the question that many of us have right now, and we'll have to see how this plays out, is does DASA and the new amendments to DASA create a right or an ability, or even just give a student who has been bullied a leg up to bring a lawsuit against a school district that has not complied with these requirements? And how will that play out with respect to a student who is being bullied because of something that happened off of school grounds? So the school districts are really put in the middle of this electronic communication by these new provisions in DASA. And I'm not going to go through all of these on slide 52 because it would take a long time that we don't have. But under the new amendments to DASA, districts have to adopt new procedures that do all of these things. Primarily, what you will see in here is making sure that school districts have an available, understandable, functioning investigation process that will result in action by the district where inappropriate, remediation with respect to a particular situation that arises, and potentially a more general solution vis-a-vis training, et cetera, if it's necessary. So it's going to be very similar to those earlier cases we talked about. When a school district knows or should know what's going on, has it taken action? Does it have all the procedures in place to ensure that parents and students can make complaints and that those procedures will be effectively implemented? The Iran Divestment Act. This was signed into law in January. It was effective just this past April. It amends the state finance law and the GML, and what it tries to do is exclude companies that invest in Iran's energy sector from entering into contracts with school districts. The Commissioner of OGS, that's the Office of General Services, as you know, has to develop a list of persons or entities who are engaged in investment activities in Iran and post the list on its website. Last time I checked, that list is not up yet, but at least it saves you from having to do the research yourself as to who those persons may be. The attempt here is to make New York's law and regarding procurement practices consistent with federal law in an attempt to stop the development of nuclear weapons in Iran. So companies that provide goods or services or credit used for goods or services of $20 million or more to Iran are now going to be ineligible for New York State procurement contracts. Any company that fits that profile is automatically deemed a non-responsive bidder. They can't bid, they can't renew a contract, they can't have a contract assigned to them. These companies now that are bidding on contracts have to certify that they're not on the list when they submit a bid. And if they're not able to certify that, they have to furnish a statement explaining why they can't certify. Now, as a district, you can still award the contract if the investment that occurred prior to April 12, 2012, as long as the investment hasn't been expanded since the law was enacted, and the company is implementing a plan to divest, or the district determines that those goods and services are absolutely necessary for the district to perform its functions. So we've provided our clients with a certification form that covers all of these bases that you should ask your counsel for to accompany all of your bids, and make sure when you go through your bidding process that you get those filled out. There's also been a change that makes competitive bidding more flexible for you. Chapter 608 of the laws of 2011, but also Chapter 2 of the laws of 2012 made changes to the GML, Section 103 and 103E. So now districts can award purchase contracts in excess of $20,000 competitive bidding threshold to a responsive and responsible bidder on the basis of best value rather than just to the lowest responsible bidder. This went into effect in January 2012, so you can already be using it. It covers purchase contracts that are over $20,000 and contracts for service work over $20,000, but it explicitly excludes purchase contracts that are necessary for the completion of public works contracts and public works contracts themselves. Now, the state finance law defines best value, and here's where your flexibility comes in. It's the offerer who optimizes quality, cost, and efficiency among the responsive and responsible offerers. And that when you make the decision, the basis of your decision has to reflect, whenever it's possible, an objective and a quantifiable analysis, which you're pretty used to doing anyway. The law also requires that districts keep the documentation, in case you get challenged, for the rationale for selection of your vendor, including the alternatives that you considered and the basis upon which you determined that the cost was reasonable. The law also requires that bids and offers have to include a statement about the time and the place when the bids are going to be publicly opened and read, and where the identity of the bidders will be disclosed. Now, most laws come with a sponsor's memo in support, as did this, and it said that the best value, this is what the sponsor was thinking when he introduced this bill, best value procurement is supposed to link the procurement process directly to the district's performance requirements, incorporating selection factors such things as useful lifespan, quality, and options and incentives for more timely performance and or additional services. So even if the initial expense is higher, considering the total value over the life of the procurement may result in a better value or best value and long-term investment of public funds, that's where your flexibility comes in. Just make sure you keep a record. Concussion Management Awareness Act. Everyone is becoming more concerned about students receiving concussions, or even, professional football players. There's been a lot in the press. So this new law went into effect on July 1st, 2012. The Department of Health and regions have to adopt regulations for the treatment and monitoring of students who experience concussions, either in school or at a school-sponsored activity. The regions just put in place their regulations on June 18, 2012, requires training of coaches, phys ed teachers, nurses, and certified athletic trainers to learn how to recognize and monitor and seek treatment for concussions. SED and DOH are supposed to post information on their websites defining concussions, the signs and the symptoms, etc. I haven't seen that up yet, but maybe in the past few days it has gone up. Important for districts, they have to create new permission consent forms for student participation in interscholastic sports that have to include all of the information that I've listed above about concussions. And again, we've done those for our school districts. If your attorneys haven't put that together for you yet, please get that done. They should be going out for the start of the school year. You don't want to not have that in your permission slips and then have a parent use the fact that you haven't had it in your permission slips as a basis for a lawsuit if a student is injured. And you're also supposed to post the information about recognizing concussion signs and symptoms on your own website. You can just lift it from SED-DOH. This act requires the immediate removal from athletic activities of any student who has sustained a concussion or even one who's believed to have sustained one. If there's any doubt about whether a student has suffered a concussion, the presumption in the law is that he or she has until proven otherwise, and they have to come out of the physical activity. They can't resume the athletic activity until they've been symptom-free for at least 24 hours, and they've been evaluated and received written and signed authorization from a licensed physician. And for extra class activities, not just gym, they also have to have clearance from the district's doctor or medical director. Disclosure of teacher and principal performance information. This is a law referred to earlier in the presentation when I talked about the Mulgrew case out of New York City. This was just signed by the governor on June 25th to address the disclosure of teacher performance information. There's a desire that parents know how their teachers perform based on their composite scores under the new APPR, but there's also a desire to protect the privacy of teachers, and this law tries to strike the balance. So SED is required to post the final quality ratings. We call that HEIDI, highly effective, effective, developing, ineffective, and composite effectiveness scores by school district for principals, by school for teachers, and within each district and school building by class, subject, and grade. And school districts can actually disclose to parents and guardians of the student the final quality rating and the composite effectiveness score for each of the student's teachers and the principals upon request. This isn't a FOIL provision. Parents don't have to go through FOIL, and this information about individual teachers, their names, their score, is not releasable under FOIL to the public. It can only be released to parents or guardians if the student has that teacher or that principal. And the information can be given by phone or in person or in writing. It should be accompanied by an explanation to the parent, and the district has to try to make sure that the requester is a bona fide requester. We don't want the press calling up and asking for particular information on a teacher and then having it public. Again, it should not include personally identifiable information, but nothing impairs the rights of parents to review and receive the final quality rating and effectiveness scores of the individual teachers and principals, which to me means that the parents can have the names, but no one else can. So we'll see how this develops. It's going to be tricky not to have this information get out publicly. Just a few quick things, and then we're done. A couple of extenders. The law giving districts authority to make conditional staff appointments pending the completion of fingerprinting and criminal background investigation process has been extended yet again. It's been extended many years for another year. So conditional appointment is still possible. There are two bills that I thought were important that as of yesterday were delivered to the governor but not signed yet that you should know about. First one, Assembly bill, would prevent a reduction of state aid up to 10 days when a school is in session less than the 180 mandated days as a result of extraordinarily adverse weather conditions, a federal declaration of a national disaster, natural disaster, and you'll see the other things if this law passes. There are a few other categories, so that's great. Also good news, the next Senate bill, if it's signed, Superintendent Conference Day bill would allow districts subject to collective bargaining to hold superintendent conference days during the last 2 weeks of August, but also count them toward the 180 days required for state aid. More good news. That brings us to noon, or 12:02, just about, and that is sort of a tour of probably the most important developments this year in case law and also statute and regulation. If anybody has any questions they want to send through Matt, our moderator, I'd be happy to try to answer them, and I thank you for your attention.
All right, thank you very much, Kathy. Do you want to take questions now, or do you want to just have them email me?
However they want to do it, or however you want to do it, is absolutely fine with me. I don't want to keep anybody past their designated time or their lunch hour, but I'm willing to do what works.
Okay. If anyone has any questions for Kathy right now, what we can do is have you hit the raise hand button, and that'll notify me that you do have a question, and I can put you through. We'll give you maybe 10 or 15 seconds to go ahead and do that. If no one has any questions, please feel free to email me. It's mdarius@nysasbo.org. I will definitely facilitate getting the question to Kathy. Back to you. So if anyone has any questions they want to ask live, go ahead and hit the raise hand button. Okay, we have a question from Terry Sweet. Terry, are you there?
Yes.
You're live. Go ahead.
Will the PowerPoint be available to print?
Yes, a email was sent out to everyone before the session. It's also, there's a link in the chat pane on the right-hand side of your screen. You're welcome. Okay, we have a question from Lori Baum. Lori, you there?
It was the same question.
Okay. All right, with those out of the way, we're going to go ahead and end the webinar for today. Thank you all for attending, and Kathy, thank you for putting this together for us.
Okay, thank you so much. Everyone have a good day.
Have a great day, everyone. Thank you.